My client has zero income, but even if we impute her to minimum wage, that's approximately $12.57 a month. There's a $4,791 difference in the incomes of these parties. 25% of that we believe is reasonable to look at as potential spousal maintenance. So we would ask the court to order or modify the temporary orders and order temporary spousal maintenance amount of $1,200 a month.
Welcome to The Wall. In today's video, we're going to look at a case involving a mother with a history of alcoholism who's been unemployed for over 2 years, suing the father of her child. She's seeking spousal support, child support, and on top of that, requesting primary custody of the children. We want you to smash that like button and subscribe. We're on our way to 150,000 subscribers, and with your support, we're going to hit that goal. Drop your experience or opinion about these kinds of cases in the comments. And without further introduction, let's get started.
All right, good morning.
Morning, Judge.
Morning, Judge. We are going to go on the record in Brian Farthing versus Catherine Farthing. It is 2024 DM 311. The petitioner appears at the office and with Ms. Locke by Zoom. The respondent appears separately from her attorney, Ms. Huntington. There are several motions here filed by respondent. And so I will start with you, Ms. Huntington.
Thank you, Your Honor. I think the first motion that I would like to tackle is our motion to transfer venue. That may take care of everything else depending upon how that goes. These parties were married for 15 years, and the last, I want to say 12 or 2 years, I don't know exactly, lived in Sumner County. They purchased a house there. The children were going to school there. They had no connection to El Dorado or Butler County until the petitioner left the marital residence and moved to El Dorado and filed this petition for divorce. We anticipate that there will be some issues regarding custody and parenting time, property issues that we may need to call witnesses to testify. Out of convenience of the parties, we believe that this case should be transferred back to Sumner County, where all of those things would lie, the school district. If there were some police reports for domestic violence between the parties, if we need to call those individuals, it would just be more convenient for those individuals to make it and appear should the court set this matter for an evidentiary hearing. And second to that, Your Honor, my client has some concerns about interference by the petitioner's family. Apparently, one of his family members is on the county commission, and she's concerned about how she might try to interfere with this process if it's in Butler County. But our main concern is that we believe venue is more appropriate in Sumner County than it would be in Butler County. And for those reasons, Your Honor, we would ask that the court enter an order transferring venue back to Sumner County.
All right, Ms. Locke, just a minute, please. All right, I think I may very well end up potentially with some charging issues. So although I guess you can see me okay from here, I'm going to get plugged back in. All right, I'm ready for you.
Thank you, Judge. The pertinent statute here, Your Honor, is KSA 6607, which essentially sets forth the proper venue for a domestic relations action. A1 states that a divorce or marriage action may be brought in any county in which the petitioner is an actual resident at the time of filing the petition. The Kansas Supreme Court in Blair versus Blair stated that residence, in this instance, is a place which in good faith would become one's actual residence, regardless of the amount of time that the individual has lived there. On July 15th, or approximately around that date, My client moved to El Dorado. He has significant family history in Butler County and in El Dorado. His parents reside in El Dorado. His sibling resides in El Dorado, and have for the majority of their lives. So when there were issues in the marital home, he moved to El Dorado. He moved here with the intent to stay. 45 days after moving to El Dorado, he filed the petition for divorce in Butler County. It's our position that he had established a residence here, that he was living here with the intent to stay here. He had taken the steps to enroll the children in school here. They have attended school in El Dorado since the petition was filed and the temporary order was granted. He has the choice of where to file his case. Butler County and the state of Kansas is a one-party divorce state. So he did not have to notify Miss Farthing of his intent to file for divorce. He filed for divorce in the county of his residence, which is his choice. She was properly served, quickly retained counsel. That counsel stepped away, and now Miss Huntington is her counsel. We think venue is appropriate in Butler County, and we would ask the court to retain venue. The court already has subject matter and personal jurisdiction, and just proceed with this case as already filed.
The woman's attorney was clever in bringing up the domestic violence allegations in Sumner County. Given the amount of evidence she could present, she would have a clear advantage if the case were evaluated solely in that context. The fact that the man has a family or children doesn't change the nature of the legal dispute, as it's specifically a conflict between him and his ex-partner. On the other hand, the male defense was strategic in pointing out that in the state of Kansas, divorce is unilateral. This means that both parties' consent isn't required to initiate the process. One detail that stands out is that the woman initially hired another lawyer, who later decided to withdraw from the case. This isn't a common occurrence. Regarding family interference, remember, the judge tends to rely on demonstrable facts, not assumptions. But let's continue.
Okay. Well, I believe with him living, as he stated in his petition at 3156 Northeast Highway 177 in El Dorado, Kansas. I think venue was proper for him to file here with regard to a matter of a convenient forum. Fortunately, with the advent of Zoom proceedings, teachers, other professional folks, we can do hybrid hearings, we can do Zoom hearings, we can accommodate parties so they don't have to travel. I think a lot of times I look at some of these issues as to what could a party reasonably expect. And I think that your client could anticipate, if he's from this area with the majority of his family here, if they separated, that's probably the direction he would go. So it's not as if he just ran off and tried to find a county where he thought he could find somebody would be sympathetic to him for one reason or another, with actually no ties or connections to the community. He has those things. So I think we're far enough down the road that I'm going to deny the request to change or transfer venue today. So go ahead and proceed, Ms. Huntington, with your motion to modify.
Okay, thank you, Your Honor. This case was filed in September of 2024, and in the temporary orders that were granted ex parte, the petitioner moved out of the marital residence, which was over $3,500 or right thereabouts, and the total household expenses were over $5,000, knowing that my client has not been employed for over a year. and he left her in the residence. And those did not get modified in 14 days. So I understand the court's not going to go back and do that. That did not happen previously. But we are asking for modification of these temporary orders. That was one of the first reasons that we had asked for it. She continues to look for employment. She's enrolled in a program for medical coding, and those classes will be started. But the petitioner knew that she had no income, yet he proceeded in a manner that was not the status quo of the parties, obtained these ex parte temporary orders that left my client in a horrible financial situation. She has moved out of the marital residence at this point, and has moved into a apartment with her 87-year-old grandfather that was also living with the parties in their marital residence. And so she's got out of the house. There's a separate motion filed by the petitioner to put the house on the market, and counsel and I have already spoken, and we don't have an objection to that, and we're in agreement. And I think she may have already drafted an order for my review. But there remains to be a huge disparity in income between these parties. There was no spousal maintenance awarded to my client in the temporary orders. There was child support ordered against my client for $350 a month, but I don't know how that number was calculated as far as what they took into consideration. Your Honor, we are asking that the court look at the domestic relations affidavit filed by the petitioner. He's indicated he makes $6,048 a month. My client has zero income, but even if we impute her to minimum wage, that's approximately $1,257 a month. There's a $4,791 difference in the incomes of these parties. 25% of that we believe is reasonable to look at as potential spousal maintenance. So we would ask the court to order or modify the temporary orders and order temporary spousal maintenance amount of $1,200 a month. The child support, right now the petitioner gave himself primary custody of the children, and that's what it is under the temporary orders. They had the temporary order set at $350 a month in child support. I didn't get it filed until this morning, and I think my staff sent it over to Your Honor. It was a proposed child support worksheet. And if the court were to grant our request for the $1,200 spousal maintenance, the child support obligation to my client would go up, but yet she would have some additional income. So it would be $581. And that, like I said, Your Honor, that child support worksheet was sent over to Your Honor earlier this morning as a proposed.
God damn it! You can't make this shit up!
I have to laugh at this situation. The woman didn't even come to ask for custody of the children. Quite the opposite. What she wants is for the man to pay her $1,200 a month in spousal support. In other words, she's demanding alimony for herself. The most ironic part is that she doesn't care if the child support goes up from $350 to $581 a month. If that happens, the man would basically be paying child support to himself. It's absurd. Now, if the house is sold, she'll receive 50% of its value. According to Kansas law, KSA 23-2902, spousal maintenance is discretionary, not automatic. The court can award it temporarily or permanently, but it must consider factors such as the duration of the marriage, each spouse's ability to be self-sufficient, the standard of living during the marriage, the age, health, and education of both parties. In this case, we're talking about a woman between 40 and 45 years old, perfectly capable of working, so it should be denied. I've always seen it as an injustice that, if you no longer live with someone, you still have to finance their lifestyle. You're not their father. That woman is no longer part of your household. To me, this is modern slavery disguised as family law. But let's keep analyzing what her lawyer is proposing.
Worksheet. But in addition to us asking for modification of the temporary orders as it relates to spousal maintenance and child support. We're asking for modification as to custody and parenting time. As I mentioned, Your Honor, in the temporary order, the petitioner has primary residential custody of both of the children. Dane is 14 and Seth is 12. Seth has repeatedly asked to go back home to be with his mom. He wants to return to his to the school that he was attending before. Dane hasn't said a whole lot about which way he wants to go, but my client is asking that custody be modified back to her as primary residential parent. We've submitted a proposed child support or parenting plan that is at Exhibit C in our notebook. This proposed parenting plan would have the respondent or the petitioner with weekend parenting time and then additional parenting time as agreed by the parties. We believe this is in the best interest of the children. That is the school that they were accustomed to. That's where they had friends. They were doing well in the school, Your Honor. I've also attached as exhibits K and L, showing that the older son, Dane, is struggling in school where he's at now. He's got D's and F's in his classes. We believe returning him back to the environment, well, into the school system that he was at in Belle Plaine would be in his best interest. There had been some discussion between the parties about potentially having Seth go back, but maybe not Dane. We're open to looking at those things, but the primary residency being in El Dorado is just simply not in the best interest of the children. I understand the petitioner is probably going to argue that my client is struggling with alcoholism. She admits that she has over the years. There was a domestic violence incident between the parties that probably was the last straw and led to the filing of the divorce. Both parties have sought and received diversion on that case. There's a separate case against my client with her sister around the same time frame. That case has also been put in diversion, and both these cases are in Sumner County. My client attended Holland Pathways. She went through the recovery program. She completed the program as required under the Holland Pathways curriculum. At Exhibit G, Your Honor, you'll see that my client has a certificate of completion of that program. The second page of Exhibit G is a letter dated October 1 of 24 from Holland Pathways indicating how my client did with the program, that she was extremely involved in the process and working through issues that she was having. They pointed out how the divorce is impacting her and how that's played a part in the challenges that she's addressed. She also goes to the VA and has a therapist there that she sees, and she's on medication, and she continues to follow through with on the recommendations there. She's maintaining her sobriety, and she would like the court to consider all of that. And she's able to provide a safe environment for her children. She has a...
Did you say VA?
Yes.
Okay. Is she a veteran or what?
She is, Your Honor. Yeah.
Okay.
Yes. And
how long did she serve? I mean, what's the reason for not working this last year?
Well, my understanding, Your Honor, and you can ask my client directly if you would prefer to do that, but that she's been looking for employment. She's been trying to find something. Her history has been in aviation, and I think she's had difficulty getting back into that. Her last job was with Spirit, I believe, and she was laid off or let go from that. And you know, that's her history, is the kind of work that she's done, and she's been unable to find anything replace that job.
Right.
She's moved into a new house in Sumner County in Belle Plaine. It's a 3-bedroom house. Like I mentioned before, her 87-year-old father lives there. He had lived with the parties, and he had provided childcare and assisted the parties when they needed help after work, evenings, weekends, things like that. And he will continue to do so if the children are returned to her primary custody. I know in Butler County, a lot of times you like to send the parties to mediation. My client would be open to go into mediation to try to get this resolved. But we would like something done on a temporary basis to try to get at least the younger child back into the school district that he was in. He's begged and pleaded to go back and live with his mom. The petitioner is well aware of this. The petitioner has not always followed through on the temporary orders in allowing parenting time as was stated in the temporary orders. He's made it difficult for my client at times. The communications by the phones have been shut off, and my client, it's in some of our exhibits, Your Honor. But essentially, she would say, "Why are the phones off? I can't get a hold of them." And he'd say, "That's on them. They didn't charge it," and was not consistently making sure that she had communication with the children. His demeanor with her has been very short. He's called her derogatory names in their communications. Those are also contained in the exhibits that we've attached, Your Honor. So he's not done the best job of being a co-parent. And I understand that these parties are going through a divorce, and hopefully they get on the right track and they can be good co-parents, but right now that's not happening. My client has basically been shut off from her children, left in a situation where she had no income and no ability to pay these bills. And so we would ask Your Honor to take a serious consideration of modification for the reasons that we've outlaid thus far. Thank you, Your Honor.
Oh, hell no!
I've always found it amusing how lawyers, no matter the circumstances, keep repeating the phrase, "This is in the best interest of the children," like a mantra. But let's take a closer look at what this woman is actually asking for. A mother recovering from alcoholism, who hasn't worked in years, who needs constant therapeutic assistance, who has no stable job or income, and who doesn't even have her own place to live or financial independence. Meanwhile, the father provides economic, educational, and emotional stability. The mother, on the other hand, is just starting her recovery, has no income, a history of violence, and no resources. And it doesn't stop there. This woman wants alimony, wants the house to be sold, wants primary custody, and wants the father to become a weakened dad. On top of that, she wants child support. In other words, she wants to put herself in a position where she wins absolutely everything and the man is reduced to being just a provider and a visitor. Now let's take a look at how the man's lawyer responds to this series of demands.
Women.
All right. Ms. Locke?
Sure, Judge, I'm going to give a little bit of history before I respond to Ms. Huntington's argument. The parties resided in Arkansas previously and moved, Alabama, I apologize, and moved to Kansas about a year and a half, 2 years ago now, and resided in Belle Plaine. They both worked in the aerospace industry in Alabama, moved to the Wichita area to continue that similar employment. There was a history of domestic violence issues, including charges against Miss Farthing in Alabama before they moved. When they moved, this history, and this has primarily been based on alcoholism, Miss Farthing's issues with alcohol, and that was documented in the Alabama case, and then also is relevant to the court here today. In July of 2024, there was an incident involving the party's oldest minor child. He ran away from Miss Farthing's care. He called his dad. His dad said, "Call the police." He came and picked him up, and then the minor child came and resided with dad for a period of time before going back to the marital residence. When they both went back to the marital residence, there was the domestic violence issue that resulted in charges on both parties in Sumner County. And those case numbers, if the court wants them, are SU 2024 CR 180 and 181. Both parties are on diversion on those cases. However, my client in July of 2024 was told that he could not return to the marital residence. He was to have no contact with Miss Farthing, and that at that time he moved to El Dorado. Ultimately, he ended up filing for divorce. When he filed for divorce, Miss Farthing entered into a treatment program. So there's some argument that she should have been the primary parent this entire time, but obviously she could not be the primary parent when she was in rehab. And Mr. Farthing acted as the primary parent. The kids needed to go to school. He's living in El Dorado. He enrolls them in El Dorado schools, which is obviously a transition for high school and middle school age children. But they're enrolled in school, and I'm told by Dad that their grades are improving in this second semester as they get used to being in a new school, being in a new community. There's an additional domestic violence incident that is even more significant. So the charges against the parties were misdemeanors. However, Ms. Farthing was charged with a felony domestic violence incident, and that case number is SU 2024 CR 235. It's my understanding that Mom entered into a diversion on that charge as well, but that diversion did not occur until just a few weeks ago, January 21st of 2025. That charge was against her sister. Her sister has resided in the marital home off and on with the parties. Her father also has, and her sister has a history of drug use, including use. Her father also has a pretty significant history of alcoholism, and he has resided with the parties. So my client leaves the house in July, and then files for divorce. Ms. Farthing enters into treatment, which we think is excellent, and hope that she maintains her sobriety. But the kids needed to be provided for at that time, and Ms. Farthing continued to reside in the marital home. Mr. Farthing had to get a new home here in El Dorado. So the natural result of that was that Ms. Farthing was assigned the marital residence where she was living with her father and had been since July, when Mr. Farthing was excluded from the home by the police. And she had the payment obligations for that, starting with the temporary order. The mortgage was paid up until September. All utilities were paid through September, despite him having left the home in July. Not through September, but to September, so through August. And I think the parties have reached an agreement about selling the marital home, and I believe I'll be filing an agreed order for that to occur, because neither party is living there, and I don't think the parties, either one of them, can afford to live there on their own and individually. However, it has been appropriate during this time and transition, and while Ms. Farthing dealt with her criminal charges, while Ms. Farthing went to rehab, for Mr. Farthing to be the primary parent. And he was here in El Dorado, so the kids went to school in El Dorado. The kids have regularly visited Mom on the weekends, so we're not sure what these allegations about them not going are related to. The kids spent the majority of Christmas break with Mom. And I think that Miss Huntington and I will be able to reach an agreement on a parenting plan moving forward, and perhaps a divided residency plan, allowing Seth, the younger child, to return potentially to Mom's care, while Dane, the child that has a history of running away from Mom's care, would continue to reside with Mr. Farthing. So we would ask the court not to modify parenting time at this time, but allow the parties to work towards that agreement relatively quickly. Related to spousal maintenance, Ms. Farthing has a history of working in the airline industry. She lives in the aviation hub. There is no reason that she's not employed, especially with veteran status. We know that her alcoholism has impacted her ability to have employment in the past, but at being clean and sober, she should be able to have a job. So we would ask that the court not make any spousal maintenance awards until she documents and demonstrates to the court that she is seeking employment in some way, or seeking some sort of VA benefits related to any reason why she's no longer in military service. Additionally, related to child support, If there's a modification in custody, obviously that will result in a modification of child support. The current support order is $305 a month. Ms. Farthing has not made any attempt to make any support payments. Mr. Farthing has been primarily responsible for the children, been paying their bills, been making sure that they're taken care of. So we would ask that the court just maintain the current support obligation. It is based on a minimum wage, imputing Ms. Farthing at minimum wage, the temporary order child support worksheet, which was filed when the court issued the temporary order.
No, God! No, God, please, no! 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 No!
This was not in the best interest of the children. This man has done everything for his family. We're talking about someone who left Alabama due to accusations of violence and had to move to Kansas. And what did she do? She fell right back into the same patterns: alcoholism, conflict, and chaos. This man was removed from his home based on a police accusation, typical in this country. He had to move to another city, reorganize his life. And even then, when his youngest child had a crisis and called the police, he was the one who acted, who showed up, who took responsibility. Where's the argument that she's the better option for the children? Let's not even get into the criminal record of her family. A sister with drug charges, a father with a history of alcoholism, all of them living under the same roof. He hasn't demanded retroactive child support or asked for anything excessive. Meanwhile, the other party hasn't paid a single cent in child support. I have to say it. This man's lawyer is doing an outstanding job. That's why I appreciate when men choose competent female attorneys. They see more clearly through the lies and slander that get thrown at men.
And where does your client work?
My client works at Spirit, Judge. Ms. Farthing also used to work at Spirit.
And he's making how much?
He makes gross about $6,000 a month.
And I'm sure you filed the DRA.
We did, Judge.
How much he has left over. What's his rent?
And I don't think that was on the initial DRA because at that point he was living, it's $1,600 a month is what was allocated to rent.
Your Honor, he indicated on his DRA that his total left over was $5,828 a month.
I don't make that a month. I don't bring that home a month. I gotta rent.
Well, the problem is that even if I order him to pay her $350 or $500 a month, whatever the case may be, she owes over $300 a month in child support that's not being paid. And ultimately that leaves her with a couple $100. Which may not even feed her, let alone the kids. So I'm not really sure what to do here.
Your Honor, I don't know if it's even necessary, but I mean, this was the status quo was they were married and she wasn't working.
I know
he
that there was a lot going on. I think her employment was affected by her addiction issues, and I think she could have been working. This is not a displaced mother who stayed at home with their kids all during the marriage, and he took off and left her with nothing. I mean, she's had since August knowing that they were separated to get back to work and get some income. And I don't think just because she's not working, he should fully have to fully support her. However, at the same time, I do believe, Ms. Locke, even if this court doesn't order any kind of permanent spousal support, I am often inclined during the transition phase and divorce phase to provide for some temporary support until people get on their feet. The reality is she doesn't have a job. So I am going to order that he pay her $800 a month in spousal. I'm not going to modify the child support obligation at this point in time. And I'm not going to change the custody. I'm going to give you guys a few weeks to come up with an agreement, or I'm going to ask that the parties enter domestic conciliation. Ms. Locke, your client's probably going to have to front the money for that, but then I will order as part of a judgment at the conclusion of the case, a portion be assessed to her.
No! God, please, no! 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 No!
To me, this is completely unfair. We're talking about a woman who is perfectly capable of working, with prior experience in the aerospace industry, yet she's been unemployed for over 2 years. How much more time does she need to get her life together? She's living in a shared house with people who don't even contribute to the rent, and still the court decides that this man, who is working, who does support his children, and does pay his bills, has to continue covering her expenses. By what logic is this justified? They calculate his income, $6,000 a month, but they don't take into account that from that amount, he has to pay $1,600 in rent, plus food, gas, school expenses, clothing, utilities, transportation, and everything else involved in raising 2 kids. And the worst part, she hasn't paid a single cent in child support since the divorce process began. This man isn't asking for retroactive support, nor is he demanding anything excessive. He's simply doing his part as a father. Yet he's ordered to pay $800 a month in spousal support to someone who contributes absolutely nothing. Do you think that's fair?
So it would just be to get the ball rolling. So that might give both of them motivation to work something out as opposed to the cost of conciliation if there is a common ground that's in the best interest of the kids that they can come to. Obviously, if they do come to an agreement to split the boys because they genuinely believe it's in their best interest, that's going to change the child support, and you have to redo the schedule. And at this point, I'm not going to impute more than minimum wage to her right now. I'm also not going to give her enough money from him in the way of spousal that she's comfortable enough with living with her dad that she doesn't have an incentive to get to work. Now, I do wholeheartedly understand when people are in recovery, that has to be their number one job and priority. And generally, people who are alcoholics are very selfish people by nature. But when they are in recovery, they have to be selfish to maintain their sobriety. So I understand that her employment is important, but I do think her sobriety and recovery is paramount. So I'm trying to weigh and balance all of that, frankly. And I'm just hoping that it seems pretty obvious to me this is not a reconciliation situation. There's been criminal charges and a lot of repercussions of them living together. And I'm pretty sure it's had an impact on the boys. So I think now they need to look at this as how are we going to move forward with our own life and co-parent? I'm also disappointed, but for them, but I understand that there's probably not much equity. This is a $325,000 house. And if they sell it, you know, it may end up being sort of a short sale, and foreclosure if they don't hurry up. So I don't think there's, money that's going to come from that for the parties to transition, and specifically a mom to transition into her housing. And right now, when she has the kids, it has to be at her dad's house. So hopefully she can convince him, if he consumes alcohol, to not do it while she has the kids. Really not in her presence if he cares about her sobriety and recovery. But we're just at one of those situations where there aren't very many good answers here. But you need to just roll up your sleeves and get to work and see what the best scenario is for both of them at the least amount of money. So,
Your Honor, may I ask a
Ms.
question?
Farthing, do you not receive any benefits, VA benefits? Have you never filed a disability claim for them to rate you?
I have lawyers working on a full and complete disability for me right now, but it's been a very long process.
Okay.
The reason why I do not want to get back into aircraft is because I physically cannot do it anymore.
Okay.
My hands, my wrists. That's why I'm trying to go to school to take up a new career.
Okay.
And
All right. We'll look at those things. Keep communicating with your attorney. Ms. Locke, would you journalize the sale of the house?
Yes.
And Ms. Huntington, would you journalize today's hearing?
Yes.
And then do you want to date in 30 days to see if you can't have some agreed parenting orders, or notify the court that they're in conciliation?
Yes,
Yes.
Your Honor.
Yes.
One point of clarification I would ask, there is the mortgage on the house. Neither party is living in the house. What do we do with that?
I think that it's probably not going to get paid. That's what I'm saying. It's going to end up in foreclosure.
Okay.
And hopefully just an interim judgment, or they'll find a buyer real quick, that they can do a short sale, or figure out a way to maneuver a sale that would include them being able to get out from under their mortgage. I guess I'm not going to order either party to make payments on the house and just hope that it can be put on the market and sold quickly. Now you've got the whole other issue though of, is the water still on? Are the pipes going to freeze? Is there anything in the house that could, any animals or anything that could destroy the house? I mean, you guys could get hit with the deficiency judgment, and if the premises are deteriorating in any way, and that would not be beneficial for anybody. So I just don't have enough information to make all of the orders. I just think that we need to get the order to sell on file, and see how long they can go without making payments on it. If they can sell it, if they can get out from under everything.
Judge, we would ask that the arrearage, the temporary child support arrearage, be reserved for future ruling, if that is appropriate and journalized in Ms. Huntington's journal entry?
Yes. All right, if there's nothing further today, let's just get, I could do the 12th, the special setting on the 12th, or I could potentially maybe do a special setting on the 4th.
The 12th would work best for myself.
I'm available on the 12th as well, Judge.
Okay, what time would you all like? I'm just busy between 1:30 and 3.
Would this same time, 11 o'clock, work?
Hey, bro. What? Oh my God!
To me, this is completely unfair. We're talking about a woman who is perfectly capable of working with prior experience in the aerospace industry, yet she's been unemployed for over 2 years. How much more time does she need to get her life together? She's living in a shared house with people who don't even contribute to the rent, and still the court decides that this man, who is working, who does support his children, and does pay his bills, has to continue covering her expenses. By what logic is this justified? They calculate his income, $6,000 a month. But they don't take into account that from that amount, he has to pay $1,600 in rent, plus food, gas, school expenses, clothing, utilities, transportation, and everything else involved in raising 2 kids. And the worst part, she hasn't paid a single cent in child support since the divorce process began. This man isn't asking for retroactive support, nor is he demanding anything excessive. He's simply doing his part as a father. Yet he's ordered to pay $800 a month in spousal support to someone who contributes absolutely nothing. Do you think that's fair? We've reached the end of the video, but before we go, the questions are for you. Do fathers always have to pay, no matter what happens? Why do judges always consider the mother's situation, but never the man's, when making their decisions? If you enjoyed the video, make sure to give it a thumbs up, subscribe to the channel, and hit the notification bell. Your support means the world to us and motivates us to create more content. Stay tuned for the next exciting video from the wall.